Well, here we are again. Like I said, I'm gonna continue these things as much as I can, and hopefully you guys will be able to put up with me in this format. So what we're gonna do today is we're gonna continue warrantless searches. It's the second part of it. I'll get through as much as I can in about an hour. I'm trying not to let these things go more than an hour, so I'll try to work quickly and get to the point. If you guys have any questions, of course you can't engage me right now personally, but you can email me. So please, if you have any questions, email me and listen as usual for the video password, which will be somewhere in here. You'll know it when you hear it. And you know, again, this is part of my coronavirus chronicles. Kramer's coronavirus chronicles continues. We refer to that as alliteration, which is when you repeat a consonant sound. Anyway, you guys knew that, right? What's it called when you continue a vowel sound? When you repeat a vowel sound, that's called assonance. Yes, that's right. Okay, let's go on. Let's get back to criminal procedure here. I hope you guys are enjoying these things. And again, I've made a test available to you earlier this week, and you should be getting done with that. And again, sending it to me in a Microsoft Word format. And then at some point, I'll be quizzing you on this material as well, or maybe I'll just let this go to final exam. But I'll be keeping in touch with you about this. Okay, so I saved this as the first thing I wanted to talk about today because when we talked about it a little bit in ADJ 101, you should remember that it is one of those bases for allowing us to sort of violate the Fourth Amendment's requirement that you have to have a warrant. Remember that's what we talked about with Mincy versus Arizona, that the bottom line is that warrants are required. But if you've got an exception, you don't need a warrant, right? And that applies to arrest warrants as well, which I think to some extent we already talked about with John Doe warrants, right? So one of the exceptions that allows us to sort of go beyond the Fourth Amendment warrant requirement is this thing called exigent circumstances. And exigent is anything that is emergency or that requires or that demands that there be action without a warrant, or essentially there's no time to get a warrant. I mean, this is a great example of, the sound of toilets flushing as I'm knocking at the door. That's a sign that I probably am going to be allowed to go in because it looks like there's an exigency created by the immediate destruction of evidence. And when do we allow these sort of exigent circumstances? When there appears to be a need for police to act immediately, meaning right now, in order to avoid danger to themselves, danger to others, destruction of evidence, or the flight or escape of the person that is the focus of the investigation at that moment, right? So keep in mind that we're going to see a couple different types of exigent circumstances. I'm going to try to go over. I think I go over all of them in this particular. Yeah, I do in this particular video. So you'll see all three, and we'll talk a little bit more than we normally talk in ADJ 101 about exigent circumstance. You remember that in ADJ 101 it's very generalized. We're going to talk about hot pursuit um, and evanescent evidence, and the idea of when there's no hot pursuit, but there's a likelihood of escape or danger to others. So these are really the types of exigent circumstances that we'll focus on. Okay. And evanescence is a word that we'll talk about because it's a very important word in criminal procedure. That's the idea that something is going to disappear quickly. Evanescent evidence is something which is not likely to stick around, right? So if that looks like it's not likely to stick around, like this is an example of a highly evanescent evidence. If you don't get in there quick, it's going down the toilet. Once powdered cocaine hits water, it's gone forever. Trust me, I've seen it happen. Okay, let's talk about Warden versus Hayden. This is a case that is near and dear to my heart. Why, Mr. Kramer? Well, I'll tell you why. Because when I was in law school, the way they do it in law school, in my crim pro class in law school, um, everybody gets called on in all classes, really. But this one was in my crim pro class, obviously, like what you guys are taking, where at some point in the class you will be called on to stand up in front of the rest of the class and brief a case, right? And you never know when it's going to be your turn, but God forbid you should miss class that day, because if you miss class that day, you're going to lower in our case, if you were not prepared or you weren't present when you were called on, it took 3 points off your final grade. And in my law school, that was really important. Could be the difference between passing and failing, or being drummed out of law school or not. And guess what? The case that I had to brief in law school was Warden versus Hayden. So I know it pretty damn well. The facts of Warden versus Hayden were this. A taxi company is robbed. The police see this guy basically running from the taxi company, fits the description, and he runs, of all places, as you might imagine, into his house. Now, he runs into his house, and the police bang at the door, and the wife let the police in. And basically, it's like a little kid. The suspect is upstairs in his bedroom pretending to be asleep. Like I used to do that when I knew I'd be in trouble when my father would get home. I would get into bed an hour before he got home. I figured, my father's not going to hit a sleeping child. But anyway, that's what he was doing. Anyway, on their way up, while they're looking for him through the house, they look inside a washing machine, which was on the way up to the bedroom, right? Which was before the bedroom. You had to pass by the washing machine to get to the bedroom where they found him. And inside the washing machine, they find clothes and guns. It's, of all the places to put, well, I guess it's as good a place as any to put your guns and your clothing with evidence on it. It was in the washing machine, right? And of course, as you can imagine, all these things were seized, and as part of what we have now come to know as a hot pursuit search, and were used against the defendant, and they weren't suppressed, they weren't excluded, et cetera, et cetera. And you can imagine that that's why he appealed it, and ultimately it went to the Supreme Court and landed on, in the Supreme Court in 1967 in this particular case. At trial, he says, hey, it's an illegal search. I never gave you consent to come in. You didn't have a warrant. Therefore, therefore, everything you seized is unconstitutional. Or it can't be used against me. Now, the court decided that, in fact, yes, it was a righteous search. It was not a bad search, right? Why? Because, and of course, his conviction was upheld by the Supreme Court, and he spent the rest of the time that he was given in prison. The court decided that where delaying would endanger the lives of others, or would endanger the evidence, for example, or would potentially allow weapons to be used against them, they have to take action, right? So, this was the basis of hot pursuit, right? You can't allow a situation, you can't allow the guy to run into a house where if I delay, then these guns could be used against others or against us. We have to go in. We have to follow this guy in. And of course, there's some rules about hot pursuit. We'll talk about that in just a minute. Under the traditional hot pursuit, speed was essential. That's been referred to now as the pursuit has to be hot. It can't be cool. It can't be warm. It can't be cold. It has to be within moments of the probable cause, right? So speed is of the essence, right? And it was only through some kind of search that police officers could be satisfied that there are no weapons that are going to be used against them or others, or that someone's not going to escape. This was the basis of Warden versus Hayden's early theory regarding hot pursuit. So it does make sense. And I put this cartoon up here because it's I don't know if you can see it, but it says, in hindsight, Lefty wished he had picked a faster getaway vehicle. It's a hot pursuit with a tractor. But when we talk about speed, it doesn't have to be speed of the vehicle or speed of the person who's running, but speed of getting into the house or conducting the search in order that weapons are in a situation that could be used against police or others, if there's not a destruction of evidence or that there's not a threat of escape, right? So the modern rules for hot pursuit are, I'll get to that in just a minute. I'll go back to it. The general requirements for a hot pursuit search are these. First of all, the pursuit, as the name suggests, the pursuit must be hot. It can't be 2 days later, right? It must be from the place of the crime, or from the place where the crime is believed to have committed, and it must be continuous to the actual scene of the search, right? And it must be contemporaneous with it. It must be at about the same time. It can't be 2 days later seeing him come from the taxi company. It has to be at that moment seeing him continuous from the place of the crime to the place that you intend to search under the hot pursuit doctrine, right? Interestingly, similar to a plain view situation, the 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 pursuit must start from a lawful position. So the police must be where he starts the pursuit. He must have been in a lawful position in the first time, either there through his natural jurisdiction lawfully, or through some other basis he was starting the search from a position in which he was lawfully allowed to be there. You should remember that from plain view, which we'll talk about again today, right? Um, Generally speaking, it's only used for serious offenses. So I'm not going to be able to chase somebody from a from a parking, from like parking in a handicap space and chase him into his house and then find a meth lab and use it against him. Generally speaking, you can only avail yourself as a police officer of the hot pursuit if it's a fairly serious crime, right? Now, what's the scope? Whenever we talk about the word scope, we're talking about where. Where can I search, right? Or what can I search for? Where can I search and what can I search for? In a hot pursuit search, it is as broad, the scope is as broad as it needs to be, right? Again, it's wherever I need to search reasonably to prevent the perceived threat that that there could be weapons used against us, or that the suspect will escape, right? So I mean, it's pretty good in terms of the broadness of its scope, right? However, as you might remember, from other things that we've talked about, like the automobile exception, which we'll go into more detail in just a minute, officers can only search in those areas where the suspect and the things that they're afraid of, like the weapons, for example, could reasonably be found. So there, if he's was believed to have used a bazooka or rifles or shotguns in a bank and robbed them, and then sort of ran into his home, you probably wouldn't be able to search in the medicine cabinet in the bathroom downstairs on your way up to the bedroom, right? Only where those weapons or the suspect might reasonably be found. I mean, that's hot pursuit, right? And again, the police have to have probable cause that the person that they're chasing is the person that actually committed the crime, right? I can't, for example, chase some other guy that came from the bank into his house if I just, well, it's, hot pursuit. Hey, somebody robbed the bank, let's chase this guy. It doesn't work that way. You have to have probable cause. Again, as you know, probable cause is that, information which in its totality would lead a reasonable police officer to believe that a crime has been committed and that a specific person committed it. You have to have PC to believe that the person you're chasing under hot pursuit is the person that actually you feel committed the crime, and that the place where you follow him, the place into which he runs, is the place in which he is. You can't sort of lose sight of him and then say, well, okay, it's one of these three houses, let's go into this one. It doesn't work that way either. You have to have, again, PC that he's in a specific place and that this is the specific guy that we're chasing. You can't just use it as a fishing expedition, if you remember that slide, to sort of, chase anybody from a scene of a crime into any place they might run, right? Okay, this cartoon is another hot pursuit cartoon. It says, I don't believe you rob a bank, but when you're being chased, you won't run a red light. These guys rob a bank, but they stopped at the red light, and of course the cops stopped them. So it's interesting little. And I want to go back a little bit because I told you I would excuse me for having these probably out of order. So here is, come on. Here's a hot pursuit, true story. Now this is a hot pursuit seizure, not necessarily a search, but try it. You're driving 73 miles an hour in a 55 mile per hour zone. Maryland State Police try to stop you to issue you a citation, but they don't stop. But you don't stop. Other troopers get involved in the chase, which ultimately ends up in speeds of up to 90 miles an hour. Finally, one trooper rams your car, causing it and you to crash. You're severely injured and left a quadriplegic, and if you're familiar with the term quadriplegic, it means quad meaning four. It means all four of your limbs, 2 arms and 2 legs, cannot be used. Right? Basically, you're paralyzed, what we say, from the neck down. Right? You sue in a 1983 action, which you should remember, alleging the trooper who rammed you used excessive force and therefore seized you in violation of the Fourth Amendment. Using the law on hot pursuit resolved this legal question. And I think this is an interesting cartoon because, here's, you guys ever, my kids had these. This is a child leading the police in a dangerous hot pursuit, which could result in this child being seized through a pit maneuver or being rammed in order to disable the vehicle. Anyway, I thought you'd be interested to know there was actually a case, Georgia versus Harris, 2017 case that was, and I remember this one when this one was decided. A police officer was believed to have used reasonable force when he rammed a teenager who was speeding away, um, and there was a videotape of this hot pursuit. Mr. Harris was the teenager, and the car that he was driving initiated, in this case, it initiated the chase, and in this particular case, pose a substantial and immediate risk of serious physical injury to others. This is what Antonin Scalia said in the Supreme Court, and he wrote for the majority that Timothy Scott, who was the deputy who actually rammed the kid's car and left him a quadriplegic. This is really the story that the fact pattern that I just gave you is based on. That Scott's attempt to terminate the chase, the deputy's attempt to terminate the case by forcing Harris off the road, was in fact reasonable, right? And that's the basis for assuming that if we had not initiated the chase, if we had waited, if we had held back, if we had not initiated a hot pursuit, chase, and seizure of this person, there could have been issues which we'll talk about right now. And of course, the court in making these decisions went through what we just talked about, and that is that the hot pursuit must be initiated by the police, and it's lawful to be initiated by the police if it is designed to prevent serious offenses and felonies, and it is this is of course for a search, but for a seizure it would be the same, where police believe that there could be danger to themselves or to others. So that's where you can engage in a hot pursuit, and you can even engage in you can cause serious injury to someone in trying to stop the hot pursuit if in fact it's believed that if you did not act, the person could in fact engage in serious injury or inflict serious injury on other people, right? Or on other officers. Okay, so I want to start off with this slide. This is one of my favorite slides in class. It doesn't really translate very well to this, but I like to do my imitation of somebody vomiting, which is something like rah, rah. Emesis, I don't know if you guys are familiar with this, but emesis is the fancy word for vomiting. That's a nice picture. I thought it was just kind of a funny picture. This is an emesis bag. You can imagine that an emesis bag is a bag into which you vomit. And what we're going to talk about here, the reason I post this is because now we're going to talk about when you do search, what's allowed. In other words, to what extent can I go as a police officer when I am engaging in a search under the Fourth Amendment? What are the things that I'm allowed to do? Some of this will sound familiar to you from other cases that we've discussed, right? But emesis is actually the idea of making someone vomit. You may have heard, and I'm going to tell you right now that this is the password for the week. It's emetic. I'll write it again. Emetic. And emetic, if you ever heard this, so a doctor might say, well, perhaps you should go home and take an emetic. Be careful with that. Make sure you understand what an emetic is. What an emetic is something that makes you vomit. It's a pill or a liquid that you take that makes you vomit. It's given to people who have swallowed something that they need to get it up as quickly as they can. It's not something that you want to take, on an everyday basis. It is something that can be a pill, or it can be a process. There can be a process that makes you vomit. And we're going to talk about a case that really illustrates what is reasonable, what are the things that I can do in a search, and what are the things that I cannot do in a search. So I thought I'd start off with something that's a colorful image. And the case that really started it off was Roshan versus California. Roshan versus California is a 1952 case. And and answers the question, what's the issue? What is a reasonable manner of searching without a warrant? In other words, if I don't have a warrant, what can I do in fulfilling my need to search somebody? And the facts of Roshan were actually kind of shocking. And that's why it went to the Supreme Court, essentially on the nature of how shocking it was. In fact, you'll see this term down here, which you should remember, that it shocks the conscience. You guys should remember that last time we heard that phrase was when last video, when we talked about these pulls, that when I'm knocking and announcing and I'm executing a search warrant, I have to act reasonably and in a way that does not shock the conscience. So hopefully you guys remember that. Well, we apply that standard of shocking the conscience actually came from Roshan versus California. The facts of the case are, like I said, are really very disturbing. Police try to extract from a kid's stomach, a man's stomach. They believe that he had drugs, that he had swallowed drugs. They were right, turns out. So what they do is, as an emetic, trying to force this guy to vomit, is they jump on this guy, beat him, to try to get him to throw up. They literally jump on his stomach. Read the case. The facts are shocking. So what they do is they take him to the hospital and they stick a tube down his throat and force an emetic drug directly into his stomach, of course, against his will. I mean, very few people will say, yeah, go ahead and shove the thing down my throat. Anyway, what happens is he does, in fact, throw up, and guess what he throws up? He throws up capsules that contain morphine, and are recovered. So the Supreme Court says this. There's certain places where, and this is, by the way, this picture is someone, a gentle emetic. This is someone who's, holding somebody's head, and he's giving them a gentle emetic so that they can gently throw up in the bowl. This was not a gentle emetic in Roshan versus California. This was jumping on their stomach, then taking them to the hospital and sticking a tube down his throat with an emetic drug. Anyway, the Supreme Court said, hey, this is more than just feeling uncomfortable about a search. I mean, if you feel uncomfortable, yeah, you're right to feel uncomfortable about this search. This particular set of facts, struggling to open somebody's mouth and removing what they could and then forcibly extracting the stomach contents, what they did to Mr. Roshan, this shocks the conscience. And again, that was a term that we used when we're determining what's the best way to execute a search warrant. And remember that it has to be reasonable and it cannot shock the conscience. And interestingly, the same terms apply to what we can and can't do when we're executing any kind of a search, right? Even if it's without a warrant, right? So, this is where, Roshan is really the big case that talks about that. Now, we talked a little bit about evanescent evidence. And where are we going to see this whole analysis about what's reasonable and what doesn't shock the conscience in terms of what we can and can't do when we're executing a warrantless search? We're going to see it in the cases of evanescent evidence. And evanescent evidence is evidence that could rapidly disappear. Highly evanescent evidence is evidence that's going to disappear quickly if you don't get to it. And in our rush to get to evidence like that, we are inclined to do just about anything we can do, which is what happened in Roshan versus California, including jumping on somebody's stomach, sticking a tube down their throat, et cetera, et cetera. This is, if you remember the case of Montoya de Hernandez, which we talked about in class, which was the Colombian woman who was held for, you guys will remember, it was beyond the 15 minutes of Royer, and it ended up being what, 16 hours or something, and that was a case for stops. When does a stop become an arrest? This is the Schmerber case. Schmerber versus, it's a funny name, Schmerber versus California is a similar case to Montoya de Hernandez, but it doesn't deal with stops, it deals with searches, right? So when do we have to worry about it? When we have evidence that could disappear quickly. And we refer to that to evanescent evidence, even if it's inside a person. And these are the things that people will swallow. These are these little balloons or bindles, or there's different words for them, pellets that people will wrap and shrink wrap and heat seal and then swallow. And this is an x-ray. I don't know if you can see this. It's actually fairly disgusting. But this is a person who has swallowed, it looks like somewhere between 30 and 70 of these little caplets of heroin, or probably cocaine. By the time this picture was taken, it was probably cocaine. And you can see that they are in every single component, every single part of the digestive tract, from the small intestines all the way to the large intestines, which sort of wrap around. So this person was very busy. Now, what can you do and what can't you do? Well, first of all, again, it's similar to what we talked about in Montoya de Hernandez when it came to stops, and that is, I can get inside there without a warrant if it's evanescent, if there really isn't any time to get a warrant, meaning that the potential destruction of evidence must be an immediate threat, meaning I really need to get in there right now. I need to reach in somehow and grab these things or hold this person and require that they poop it out, or that I use some kind of a stomach pump or something to get these things out. If it looks like it's immediate destruction, then I have the ability to do that under Breithaupt versus Abram and Schmerber versus California, which were two cases that really talked about the same thing. Again, there must be a clear indication that what I'm doing when I actually engage in this search, that I'm going to get something. Right? If I'm just, again, on a fishing expedition like that picture of Putin that I showed, then it's not going to work. Right? There has to be a clear indication that what I do in this search without the warrant for evanescent evidence, that it's actually going to produce something. It's going to produce, a whole handful of these things. Right? And this, of course, is, Breithaupt and Schmerber and Roshan versus California. They all basically say the same thing, that the search must be conducted in a reasonable manner. And you don't usually hear the Supreme Court talking about these concepts. But in these particular this line of cases, the Supreme Court talked about dignity and privacy. And again, these are not necessarily legal concepts. But it's the first time that in this class, you'll hear the Supreme Court talking about whether or not human dignity and privacy actually outweigh the state's interest in the search. And again, it's that whole sort of, together, it's that balance between crime control and due process. And these tended to be due process related cases, in that the court held that fundamental human rights and dignity have greater value, actually, than the evidence. So if you don't do this in a reasonable manner, and there's no clear indication that you're going to get something from it, and it's not immediate, there's no threat of immediate destruction of evidence, you're going to run the risk of losing it if you do not engage in some kind of reasonable activity to search the person. And I'll show you another example, and this is it. You're caught while intoxicated. Real pictures of people being strapped to gurneys, strapped down by police officers in order that they can take a blood test. I mean, don't let this happen to you. You're caught driving while intoxicated. You refuse to submit to either a breathalyzer or a blood draw, which can happen. So police take you to the hospital, where they tell a nurse, draw blood from this guy. Take the blood. Of course, the result is proof that you're drunk, or else we wouldn't have any cases. I mean, if we didn't gain evidence that was used against you that wasn't suppressed, and resulted in a conviction, we'd never see these cases in court in the first place, right? I mean, I'm sure you understand that by now. Let me ask you some questions. Is that a search? Right? Is this a search? Well, you guys should remember what a search is. A search is any sort of organized law enforcement effort to obtain evidence to be used in a criminal proceeding against you. I mean, that's what a search is, right? So do you think that jamming a needle in my arm while I'm strapped down and being held down by 3 or 4 officers, is that a search? Well, I would say, yeah, that's a search, right? So if it's a search, then we have to go back to the whole Fourth Amendment thing. Is there probable cause? Is there an exigent search? There's a warrant. No, there's no warrant. Oh, well, then there must be an exception. What are the exceptions we're talking about? Is there exigent circumstances, immediate destruction? Is it reasonable, etc.? So I'm just wondering if you can figure out what the court said. Can you create an argument, a ruling, why this should be allowed? Now, I can come up with a few, right? If I don't get alcohol, if I don't get an alcohol reading in this guy's blood, before I know it, it's going to be ticking down. And if I don't get it immediately, it'll go from 0.23 to 0.10, and then I'll never really know that, how much. I mean, you can argue that there's an immediate destruction of evidence because it's evanescent. Blood alcohol goes away. It peaks up to a certain point, then it starts to drop off rapidly. So if I don't get a reading now, it's not going to be accurate. Fair enough. Will it result in, these are the Schmerber criteria that we just talked about. Will it result in the gathering of evidence? Well, I think it will, right? On the other hand, you got to look at that last sort of category there, that last criterion, and that is this a reasonable search? Is it reasonable? When we talk about human dignity and privacy, does this respect? And when you look at Roshan as well, do these types of searches respect human privacy and dignity? It turns out that the Supreme Court ruled on this as late as 2013, which I think is really interesting. In terms of our class, that's a fairly recent case. And the case was Missouri versus McNeely. And what Missouri versus McNeely says, very simply, is that um, the fact that the blood alcohol content naturally dissipates, it naturally gets lower over time, is not necessarily an exigency. It's not important enough. It's not crucial enough. It's not emergency enough to justify this warrantless search. So these things, these pictures here, were all pre-McNeely. Right? You can't do this anymore. The Supreme Court said, yeah, it's true. It's gonna be, it's evanescent, right? It's going to disappear quickly if you don't get at it. But when it comes to alcohol, when it comes to blood alcohol, we don't apply that test. It ain't reasonable, right? So it didn't pass the reasonableness test. So does that make sense, the way we apply the different criteria, right? Okay, I want to go over this. This was the Carroll Doctrine. And the Carroll Doctrine is yet one more warrantless search. So we've been over this in ADJ 101, and it should sound familiar to you. So I'm going to go over it quickly. The automobile exception came from Carroll versus United States. In fact, it's still among law enforcement today. We used to refer to it as Carroll searches. It's a Carroll search or a Carroll Doctrine search. The Carroll Doctrine said that when it comes to cars, and as you guys should know, cars are a little different. A warrantless search of a car is okay if the officer has probable cause to believe that the automobile contains some kind of contraband or evidence of crime, right? And as is the case with most cars, getting a warrant is just impractical. I mean, it's just not going to work, right? Because cars move, right? And, if I go out to get a warrant, this guy's not going to wait for me. He's going to be gone. It turns out, interestingly, in 1925, the original case involved 68. Mr. Carroll was driving a car that had 68 bottles of illegal liquor in 1925. That wasn't a good idea. The officers had been tipped off. They believed that his car had alcohol, and what they do is they stop the car and they search the car. Keep in mind that the automobile search, or the automobile exception, or the Carroll Doctrine exception, same thing, is based upon a suspicion that the car contains contraband. There's no suspicion as to the driver. However, it's really just, it's almost a fiction, because we're going to get to him. Once we search the car is the suspect. Once we search the car and we find the bottles, guess who I'm going to turn to next? Yeah, I'm going to turn to Mr. Carroll. And then I'm going to place him under arrest. But keep in mind that at least initially, Carroll Doctrine searches, or automobile exception searches, involve a suspicion of the car, not the driver. Right? And that's why they were allowed originally in 1925. Right? So what the basis is for the, and I'm going to put them up here, all three of them. I hope there's enough room there. Yeah. There's three reasons why cars are different. Why did the Supreme Court allow the Carroll Doctrine? But still good law. 1925, still good law. Number one, cars are inherently mobile, which means there's something about the nature of cars that they just want to sort of go. You put the key in them, you put your foot on the gas, and hey, it's moving. So because cars are naturally mobile, their nature is to move, it's impractical to get a warrant. You have to sort of work on it now. So that's one reason. The other is that we have a reduced what? You have a lesser expectation of privacy. Right? Why? Because cars are held out to the public. When I'm driving down the road, people can see me. Hey, there he is. Hey, they wave at me. They see me while I'm a half a block away, right? Because we hold ourselves out to the public in our cars. People can see us. People can know our cars. They know us, right? So when you hold yourself out to the public on public roads in a car, your reasonable expectation of privacy is decreased. Right? I hope that makes sense, right? And as I think we've talked about in one class or another, cars are subjected to significant government regulation, right? And that includes, insurance and emissions control and licensing and inspection, and you name it, right? All these things are things we have to do that the government sort of wheedles its way into our vehicular lives. So for these three reasons, the Supreme Court said, yeah, cars are different. There's a lesser expectation of privacy in our cars. We can sort of stop the car, search the car in the middle of a highway if we have probable cause to believe that, in fact, it contains contraband. Now, notice how in the automobile exception, the Carroll Doctrine exception, we're not focusing on exigency. We're focusing on privacy. I don't pull the car over because it's got, if I see you snorting cocaine inside your car, that would give me probable cause to believe that the car contains contraband, and I can stop the car under a Carroll Doctrine search. But I'm doing that not because of exigency. I'm not doing it because I think you're going to kill somebody, or you're going to hurt somebody, or you're going to flee, or there's going to be immediate destruction of evidence. I pull you over because there's a diminished expectation of privacy, and I'm allowed to. Because you have a diminished expectation of privacy in your automobile, which is basically this, right? I can stop you. So these searches, these Carroll Doctrine searches, are not necessarily based on exigency. They're based on REP, on reasonable expectation of privacy, right? Okay, so again, sort of bottom line here, what are the things that we need for an automobile exception search? We need, or Carroll Doctrine search, which you guys can simply call an automobile exception. We need probable cause that the vehicle contains, the original term used in 1925 was contraband, right? Evidence of crime. And so be careful. Now, keep in mind that under the Pacheco case, which was just decided, I think, a couple of years ago in the state of Maryland, the Court of Appeals, which is our highest court in Maryland, police can no longer use the smell of marijuana as the basis of probable cause, right? So you can be puffing away on your blunt or your joint or your bong, whatever, in your car with big clouds of white marijuana smoke coming out of your car, and the police officers can no longer use that as a basis to stop you under the Carroll Doctrine or under an automobile exception search. That's new law. That's brand new law, right? And of course, the idea that it's in a car suggests that it's just impractical to get a warrant, right? It does only apply to automobiles, but the question here, as you might imagine, is when is a car, and when is it a house? When is a car, and when is it a house? You're probably thinking, what the hell are you talking about, Kramer? Well, it turns out that there was a case, a Supreme Court case, again, came out of California. California versus Carney answered the question, when is it a car? Well, it's pretty obvious when it was a car. Well, in the Carney case, it wasn't, right? The questions they had to ask was, is it stationary? In other words, is it moving, right? Or is it standing still? And under what circumstances could a car be a house when it's not moving? You could probably figure that out. If it's in a campground, if it's up on blocks, right? I mean, if it's up on blocks and it's hooked up to sewage and water, it ain't a car anymore. Now it's a house. The rules are different. Is there a license plate on it, right? Is it connected to utilities? All these things would suggest that, hey, maybe it's not a car anymore, because this is a big deal. If it's not a car, then it's not subject to the automobile exception. Then you go back to what? Persons, houses, papers, and effects, the original language of the Fourth Amendment. It's become a house. It's not a car, right? I got a couple pictures here I just wanted to show you. Now, let me see. I can't. What this bottom one says here, does it have access to the road? And if it looks like it has access to a public road, then these would be things that you would be considered in determining, in fact, that it's a car, that it's not a house. I'm surprised that didn't show up on the slide, and I'm sorry about that. Anyway, look at these pictures. You tell me, is this one on the bottom? Is this a house or a car? Well, does it have access to the road? I mean, it seems to. Is it licensed? Is there a valid license plate there? Yes. Is it mobile or stationary? Well, it seems like it could be mobile, but on the other hand, look at that thing. I don't know, man. I mean, I think this is some clever attempt by some guy to trick police by saying, hey, man, it's not a car, it's a house. Get a warrant. Yeah, I'm thinking that this is got wheels on it and it looks like it's got a license. I think this is a car. Now, up here, this is a different story. This is really where we have the issues. This is where these are the ones that take you to court. As from a prosecutor standpoint, these are the ones that give you trouble. Is this a car or is this a house? Well, is it mobile or stationary? Is it licensed? Is it connected to utilities? Does it have access to a road? My guess. What do you guys think? I don't think it's mobile. I think it's stationary, because those square wheels, they don't seem like they would, they would roll very easily. It's got a stairway, it's got, whatever. My guess is that on any other day, this could be a car, but today, anyway, if we search the thing today, we're going to need a warrant. Why? Because this is not a car, right? All right, let's move on. Some distinctions. I just want to sort of, some bits and pieces here about the probable cause requirement to search a vehicle. And the difference between the vehicle and the occupants. Remember, I told you that when we search the car under the Carroll Doctrine search, we're searching the car. We don't mess with the driver until we find illegal illegal evidence of crime, and then we can turn to the driver and we can say, hey, now you're under arrest because we found PC as a result of the Carroll Doctrine search. But distinguish between the automobile exception or the Carroll Doctrine search from a search incident to arrest of an occupant or driver of a vehicle, which we talked about, right, in the last video, I think. Remember that if I've arrested a driver, right, or an occupant of a vehicle, it doesn't automatically allow me to search the entire vehicle, right? But under the automobile exception search, I can search the entire vehicle, right? Anywhere where the evidence the evidence that I think the car contains, anywhere where it might reasonably be found, right? So, then that's what goes into these blanks, might reasonably be found. So bottom line, where can I search in a vehicle after, and we've been over this, and I think the last PowerPoint we talked about this, last video. After I've arrested the driver of a car, where can I search? Well, these were the two most, the best cases. This one's now, I love this case, Belton versus New York, which said that when I've arrested the occupant of a car, I can search in the wingspan. Remember that in a search incident to arrest, I can search in the wingspan, any place that a person might reach to grab a weapon or destroy evidence, right? You guys should remember that, right? And what does that mean? Well, Belton determined that in a car, that means the entire passenger compartment, right? And then Arizona versus Gant came along in 2009 and said, I hate that case. There's my little angry face, which essentially overruled, as a matter of law, overruled Belton and said that you can only, if you've arrested the occupant of a car under Arizona versus Gant, you can only search the car if you believe that he has a chance, there's a reasonable opportunity for him to get back to the car to grab a weapon or destroy evidence, number one, which is unlikely, or number two, that you believe that there is evidence in the car that relates to the original reason why you stopped him. Remember that we talked about Arizona versus Gant. So, just make those distinctions between the search incident to arrest of an occupant and where I can search in a car, and the actual automobile exception search, which if I think the car has I have probable cause to believe the car contains contraband, then I can search anywhere in the car, under the hood, in the trunk, in the tires, anywhere, right? Okay, good. Some bits and pieces about traffic stops, because these are always without warrants, and I just, we just want you to sort of, a few things that it's important for you guys to understand as citizens and as students of criminal procedure. Can an officer ask you to stand outside the vehicle without any reason after a traffic stop? Can they ask you to get out of the car? Well, can I see your license and registration? All right. Please step out of the vehicle, sir. Does he have a right to do that? Does he have a right to do that? And do you have to comply? The answer is, and believe it or not, it was a Maryland case, Maryland versus Wilson, which is a Supreme Court case, that says that, yeah, they can make you get out of the car. If you look on YouTube, there's a number of videos about people who say, you can't make me get out of the car. You can't make me. This goes back quite a way. 97, it's more than 20 years now. You don't have any right to make me get out of the car. And the officer will gently say to them, yes, I do. I can make you get out of the car. And if you don't get out of the car, you're going to find yourself being pulled out of the car. I mean, this is all based upon Maryland versus Wilson, right? Now, how about this? You stop someone for a traffic violation. You're a cop. He's clearly not free to leave. You agree with that, right? He's clearly not free to leave. In a traffic stop, we're not free to leave, right? You begin to ask him questions. Do you need to Mirandize him? You guys should we haven't covered Miranda yet. We're getting to it. But you probably should remember from ADJ 101 that Miranda applies under two circumstances, right? Custody and interrogation. If you're in custody and I intend to ask you questions, I have to advise you of your Miranda warning. So the question is basically this. If I'm asking you questions in a traffic stop, hey, I see your license and registration. Yeah, where are you going? Where are you coming from? How come you're driving so fast? I saw it looked like you were bending under the seat when I pulled you over. Were you trying to hide something? That's to me sounds like interrogation. So, and you're not free to leave. Although the question is, the magic question here is, when I'm stopped in a traffic stop, am I in custody? Well, the answer is, guys, no. You're not in custody when I ask you to. When I pull you over for a traffic, you're detained, right? So generally speaking, this guy, when you get stopped or you stop other people as a police officer, you can ask questions that are consistent with a traffic stop without being required to issue a Miranda warning. Why? Because it ain't custody, right? Okay, how about this? You stop a car and search one of the passengers and find CDS, controlled dangerous substance, of course. I mean, if he didn't find anything and you didn't have any evidence against him, he wouldn't have been convicted, he wouldn't have appealed it, et cetera, et cetera. He alleges his Fourth Amendment rights were violated. Of course, he has whatever reasonable expectation he can have in his car, but is the passenger seized as well? What about the passenger, right? You stop a car, you don't search the driver, you search one of the passengers as well. Well, you search the driver and the passengers. What about that? Is he seized as well? Yeah, right? When you stop the car, not only can you search the driver, but you can search the passengers, right? So this is pretty important, right? Okay. All right, good. Now I want to introduce you to one of my favorite cases. I don't know if you're going to like it or you're not going to like it. Wren. Like the little bird, except that Wren is spelled W-R-E-N, and this guy's name was Wren, W-H-R-E-N. This is a D.C. case that made the Supreme Court. It started off in the Superior Court for the District of Columbia, and it deals with pretext stops, and that is the idea that I, as a police officer, can stop you for something that is not really why I'm stopping you. It's not really what I'm concerned. An example is, if you've ever driven a car and you've had in your mirror, in your rearview mirror, one of those little air fresheners, right? This one I was prosecuting. This was a big deal. This is what Maryland State Police specifically would use to stop people. That was a pretext stop. I'm not really interested in whether you have an air freshener. The basis was that the reason was of the stop was what we called a windshield obstruction. Right? It was okay. They had talked to us about it in the state's attorney's office. Yeah, it's a lawful stop, right? But the real reason I'm pulling you over is not because of your windshield obstruction, but because I think that you guys have crack cocaine. For whatever reason I think that you guys are crack cocaine dealers, and you're mules, and you're moving large amounts of drugs from one place to another. What happened, the facts in Wren were very interesting. The cops in D.C., they stopped two young black males. One officer approaches the car, sees 2 bags of crack cocaine in the hands of a passenger in the front seat. And I say, look, I stopped the car. At the end of the day, when I'm challenged on this as a police officer, I say, hey, I didn't stop the car because they were black. I didn't stop the car because I think that African Americans are more likely to be carrying crack or whatever. I stopped them because they were, they had this traffic violation, right? They had a windshield obstruction, for example, right? Now the driver says, no, you didn't. You stopped me because what? Because we're black. We're black, and you believe that black men are more likely to carry drugs, and therefore that's why you stopped us. Went to the Supreme Court. Technically, there was a basis for the stop. It was whatever we call a pretext stop. Some other, a registration sticker that's upside down, a third tail light that's out, the brake light that's out, some equipment violation, tinting, whatever. But I don't really care about the tint as the police officer. What I care about is the fact that I think, right, that you guys have cocaine in the car, and maybe even race had something to do with it. Now, you might be surprised at what the court, this is a very important case. You might be surprised at what the Supreme Court said. And what the Supreme Court said was that it doesn't really matter what the officers may have been thinking about race or about crack or about drugs, or whether they suspected the drivers based upon race. What really matters, their actual motivations to stop these 2 young black men don't matter. It's an unusual case, but Supreme Court law, dude. I'm telling you what, it's a very important law. And that is what matters was the stop constitutionally reasonable? And if I had some cause to stop the car, even if it was just a pretext, then the stop is a lawful stop, and anything I seize as a result, whether it's plain view or automobile exception or whatever, once I make the stop, is lawful. Bottom line is, police officers can use traffic stops as a basis for stopping a car if that officer suspects that there is some non-traffic related crime. In other words, even if I think that the reason I'm stopping the car is for something that has nothing to do with the air freshener or with the taillight, I'm really stopping this. I'm saying to myself, I'm going to stop this guy for broken taillight, even though I think that the real reason I'm stopping this guy is because he has drugs in the car. That's okay. As long as the stop is based upon something lawful. Bottom line is, cops can stop you based upon motivations which are unlawful based upon race, as long as the stated purpose of the stop was a lawful traffic-related crime. Does that make sense? Right? And here, this little cartoon I put up, the one officer saying another in the car, I used to feel naughty following suspects until they committed minor traffic violations, then using that pretext to stop them. But it turns out that under Wren, Wren versus the United States, hey, I've been on the cutting edge of law enforcement the whole time. So it's okay to use a legitimate basis to stop somebody, even if the real reason in your heart to stop them is based upon race or some other thing, which is unconstitutional. Interesting case, isn't it? I love Wren. Now Wren, I love it because it is so revolutionary that what it basically says is, you may have racial profiling in your heart, but as long as what's on your lips, right, as long as what the basis of the stop is lawful, it's a good stop. And basically what Wren did is it upheld these so-called pretext stops. Bottom line for us as citizens, especially if we're minorities, careful what we have in our windshields, make sure our brake lights are working, make sure our registration stickers are right, because these will be used as pretexts to stop us. Okay. Now, what does the Wren decision do for Fourth Amendment claims of racial discrimination? As you might imagine, it doesn't do much for them. It makes them a little bit tougher. It makes them a little bit tougher to uphold. I mean, it's going to be tougher for people who are saying, "Hey, I'm going to use my glasses here, guys." Yeah. It says there any other. I should have chosen another color font there. But what does it do for Fourth Amendment rights? It doesn't do much for them. It makes them much tougher for minorities to sustain Fourth Amendment violation allegations when they think they've been stopped on the basis of race, right? Any other remedies? Well, sure. You know what the remedies are. There's a bunch of civil remedies that we can, including Bivens actions and 1983 actions. Don't forget those, but those are lawsuits. Those are not necessarily going to get your evidence suppressed, right? Okay. Arizona law. True story, and decided relatively recently in 2012. Arizona had the following law. It shall be lawful for any peace officer in the state to make a reasonable attempt to determine the immigration status of any person stopped, provided that reasonable suspicion exists that the person is an alien, not from here, and unlawfully present in the U.S. Now, that was Arizona's law. I mean, Arizona was on the cutting edge of every unconstitutional statute that could possibly. They've been turned over locally and statewide on so many occasions in the past 10 years. It's difficult to imagine, right? Including Sheriff Joe Arpaio, who was the sheriff of Maricopa County, was threatened by the Supreme Court because he violated a Supreme Court order. Arizona's a stubborn state and conservative state, and really concerned about their border, right? They had a law that said, hey, anytime a police officer wants to stop somebody to check on their status, right, you can do so as long as you reasonably believe that the person is in fact not from here, right? Which means that I can pick somebody that looks Hispanic or looks Asian or looks whatever, and I can pull them over and say, hey man, can I see your papers? Are you here lawfully? Now, and this is what happens, during the stop, you ask the driver to present proof of legal status. He can't do so. This is basically what happens. He cannot do so. He admits that he's here illegally. He's transported to the local detention center. And guess what? As you can imagine, he's searched. And when he's searched, we find 2 grams of heroin. He appeals, 2012. What result? He was stopped under this law, right? Couldn't establish evidence that he was there lawfully, and he was searched as a result, and evidence was found. Well, the result is that in the name of the case, as you might imagine, was Arizona versus United States, that said that you cannot detain someone, probable cause or otherwise, solely in order to verify information about whether or not he's legal or not. Now, this is a pretty big deal, right? And what this law has been interpreted to mean that you cannot, when you pull somebody, you can't stop somebody on the basis of there being an alien and ask them to present documents. You can't do it. It's unconstitutional. If you detain them and anything is seized as a result of that detention, it's going to be thrown out. It's going to be excluded under Arizona versus U.S. Right? Make sense? Okay. let's finish up with plain view. I'm probably going to have to do another. I want to keep these to about an hour, so I'm probably going to have to do yet one more. It'll be very short. Let's talk a little bit about plain view. You know, plain view is a wonderful fallback measure. It didn't really work in the case of Coolidge versus New Hampshire, but it is something that that you will always be able to fall back on as a police officer, as long as you satisfy the three basic requirements. This is, by the way, if I'm not mistaken, these are marijuana plants being grown lawfully in Portugal, which is one of the few countries in the world which, on a countrywide basis, has legalized marijuana for any purpose, recreational or otherwise, right? Now, the question is, just because you see it doesn't necessarily mean that you can seize it, okay? For example, can you seize a marijuana plant that you see in a window as you're walking by, right? Well, the answer is not really, because if you're on private property, right? If you're on public property and you view illegality on private property, you need a warrant. Right? So you can't, for example, be walking along the street here. Hey, I'm in a public place and I see illegal. Let's say, for example, this is in Portugal. Let's say it's North Dakota, where it's not legal, or Pennsylvania or West Virginia, and I see this. Can I seize that in plain view? No, I would not be lawfully positioned. If I'm on public property and I'm viewing illegality privately, unless there's exigency. Unless there's exigent circumstances, that's what the E and the C stand for, right? I need a warrant or I need the exigent circumstances, right? Under this type of situation, right? So you guys know that what the basic requirements are of a plain view seizure, and that is that officers must be they must be seeing it from they must be seeing what they believe to be evidence from a lawful vantage point. Another way of referring to this, and way that I've referred to it, is they must be lawfully positioned. That a police officer cannot avail himself of a plain view seizure if he is not where he's legally supposed to be. Right? If he breaks into your house without a warrant and then sees a dead body, can he seize the body? No, because he wasn't lawfully positioned in the first place. He couldn't break into your house without a warrant. But if you let him in consensually, then he's there under your consent and he sees the same dead body, he can seize it. That's plain view. It has to be from a lawful vantage point. What are examples of lawful vantage points? To be able to avail yourself of a plain view seizure when you're executing a search warrant. Right? You're inside the house with a search warrant. Anything you see inside the house while you're searching, you can take, as long as it's readily apparent as evidence. Right? You can't take the Tiffany lamp and the Oriental rug, and the nice toaster oven. You can't take that. It has to be readily apparent as evidence. During any valid arrest, anything I see, this is very common, anything I see while I'm arresting you falls out of your pocket. I can't tell you how many times we had arrests, and while someone's being arrested, a bag of weed or a bag of crack cocaine falls out of their pocket. I can take it, plain view. I'm lawfully positioned. During a hot pursuit, right? While I'm chasing you under all those requirements of hot pursuit, if I'm chasing you and I see something fall out of your pocket or whatever, or while I'm initiating the hot pursuit search of the house, for example, that you ran into, and I see a couple dead bodies along the way, I can seize them, right? Plain view. During a lawful warrantless search, which is what we've been talking about, all these warrantless searches, right? If I see something at the time and it's readily apparent as evidence, hey, I can take it. And during so-called non-searches, right? If I just happen to see you walking down the street, if I'm lawfully positioned and I see something fall out of your pocket, looks like a bag of crack, I can take it. If you invite me into your house to have a cup of coffee, right? And that's a non-search. If I see something, I'm lawfully positioned, I can take it, as long as it is readily apparent as evidence, right? Okay, number two, again, and here it is, I keep saying it has to be immediately apparent as evidence, right? The particular case of Arizona versus Hicks, another Arizona case that hit the Supreme Court in '87. The guy shoots his gun through a floor, injuring someone in the apartment, down below. So the police go in the apartment to look for the weapon and other victims. Now, is that okay? Well, I would say that they're probably lawfully positioned, right? Now, that's fine, right? There's a gun fired inside a house. They go in to see if there's a weapon that could be used against them. I would say that's exigent circumstance. So they're probably there lawfully, right? On the other hand, once they're in there, guess this is Arizona versus Hicks, they see a high-end stereo system, and they think that this stereo system that they see is stolen. Now, I mean, is it readily apparent? Is it a readily or same thing, readily or immediately apparent as evidence? So they pick up the turntable. You guys remember in the old days, in the 70s and 80s, we used to buy these really wonderful turntables to play, LPs to play albums. Man, I remember when I was in college, my guy down the hall from me, man, he had the sweetest stereo system, beautiful turntable. Anyway, they turn it over, get the serial number, they call it in. Hey, it comes back stolen. What do you know? Right? They arrest the owner, charge him with possession of stolen goods, stolen property. Now the question is this immediately apparent as evidence? Right? I mean, they're in the house lawfully, but was a suspected stolen stereo system, boy, there's a little bit of alliteration for you, a suspected stolen stereo system, was that something which is readily apparent as evidence that would have allowed them to pick it up, turn it over, see what the serial number is, call in the serial number, and find out that it's stolen? And the court said, no, under those circumstances, that is not immediately apparent as evidence. You need more than a mere suspicion, right? It has to be immediately apparent as evidence, not just, yeah, that might be stolen. One of the big cases that came out of the Supreme Court in 1983 on this whole plain view thing was Texas versus Brown. I like Texas versus Brown because we used to deal with this when I was prosecuting drugs here in Washington County. Was the guy goes into a house, he's lawfully positioned, and he sees these things. He sees things that look like balloons, little pieces of balloons. And he believes, he's lawfully positioned, that these are immediately apparent as evidence. Now, if you're a kid, you might think these are little toys, very colorful. But as a police officer, do you believe that these could be considered reasonably apparent as evidence, or readily or immediately apparent as evidence? And the answer is yes. In his training and experience, he knew that balloons could be held in smaller sections of balloons, could be tied off, and were very common places to secret and conceal and store powder cocaine and powder heroin, right? So another case where this whole idea of what is immediately apparent as evidence comes up, and that was Texas versus Brown. Okay, and then just a little bit, something that an additional factor that we didn't talk about in ADJ 1 is that how else can I determine if something is immediately apparent as evidence, right? For example, could I smell it and determine that it's immediately apparent as evidence? Or could I, not only viewing it, but could I feel it to determine that it's immediately apparent as evidence? This is an interesting question, and the answer is basically yes. You can plain smell. It sounds funny, it's a twist on the plain view doctrine, but you can actually plain feel or plain smell something. But again, it has to be plain, right? It has to be plain. You can't manipulate something soft, and you can't play with it in the guy's pocket for 15 minutes to determine that, oh yeah, it's immediately apparent as evidence. It has to be plain. Anything that deals with your perception, your senses, to be able to feel it or smell it with your own senses, that actually gets you looped into a plain view kind of search. And that is, it's immediately apparent as evidence, not just through view, but through any other sense, right? And another example is the one I think I've given you in class, is an officer who sees something in a glove box but has to move things around to be sure. It looks like the grip of a nickel-plated revolver, right? So let me just make sure. He moves some things around to make sure, oh no, it's not, it's something else. Or let's say it is a gun and he seizes it and uses it against you. That would not be considered a plain feel. It has to be immediately apparent through smell or any other sense that it is in fact evidence, right? Understand? I mean, does that make sense? I'm not going to hassle you on a final about this, but keep in mind that plain view is not just plain view anymore. Now it could be plain feel, plain smell, etc. Right? Okay, I'm going to end with this little exercise for you guys, and you guys tell me what you think. Officers have a warrant for the arrest, should be officers, or officer has. Let's say officers have a warrant for the arrest of Randy Whitbeck, who is a suspect in a true story. They lawfully execute the warrant. Okay, keep in mind, they've got a warrant. You should be thinking different things. They've got a warrant. Right now, I'm thinking about search incident to arrest. I'm thinking about lawfully positioned for plain view, and they arrest him while he's at home. While there, one of the officers observes a rifle leaning up against a wall in an adjacent bedroom. with probable cause to suspect it is an illegal assault weapon. He believes that in his training and experience. Officers, which information which in its totality would lead a reasonable police officer to believe that a crime has been committed, also known as possession of an illegal assault weapon. The officer enters the room and seizes the gun. Now, at this point, can the gun be introduced into evidence? What do you think? They have a warrant for the arrest in his house. Remember from the last video, if you want to arrest somebody in their home, you need a warrant. They have a warrant. They arrest him in his home. Are they lawfully positioned? I think so. They have an arrest warrant. They go into a guy's house to arrest him. That's lawfully positioned. While they're there, they see something which is in plain view, right, with the sense of vision. It's plain, and it's immediately apparent as evidence. They didn't have to jostle anything around. It's leaning up against a wall. Can they seize it? Are they lawfully positioned with the warrant? Yes. Is it immediately apparent as evidence? Is it in plain view? Yes. I say under plain view, it's okay. Now, how about this? Can you think of any other theories that would allow them to take it? How about a search incident to arrest? Any area into which he might reach to grab a weapon or destroy evidence? How about a protective sweep, which you know they can do officers can do before they actually search a place or before they go into arrest, right? So can the gun be introduced as evidence at this point? Yeah, I think I got a couple theories there. Let's say the gun is not connected to the rape. Does that change your answer? For me, I don't care. I don't care if I think that it's an illegal weapon, I'm taking it. Under plain view and maybe a couple other theories. Remember, always go for alternative theories. Always go for alternative theories. If you don't like one, go for another. That's what I used to do as a prosecutor, right? Okay, let's say there was both a search and an arrest warrant. 2 warrants. If the officers knew the rifle was contraband, but it was not named in the search warrant. Remember, a search warrant we talked about in the last video, the search warrant has to state with particularity the place to be searched and the items to be seized. Let's say it wasn't mentioned in the search warrant, but I see it while I'm in there. Can I be introduced into evidence? Yes, of course. I'm lawfully positioned. Being one of the great places to be lawfully positioned is during the lawful execution of a search warrant. And if you see something that you believe is in plain view and that it's immediately apparent as evidence, go ahead and take it, even though it's not listed in the warrant. Right? Make sense? Okay, good. All right. Well, that, guys, is the end of today. I think I went a little bit more than, I think it's probably close to 1 hour and 10 minutes. I'm sorry. Anyway, look for more of these. As you know by now, we're not coming back until next semester, so I won't see you guys again. I'll be doing these. I might start to reduce these to weekly videos, which I'm sure you'll be happy about. And there'll be another quiz coming up.